Garden State CLE. 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 Garden State CLE.
I've been practicing crimmigration for about 10 years, and well, what the hell is that? Crimmigration is basically these two books. You guys, or most of you guys, should be familiar with the 2C book, Criminal Code, and then this one you're not familiar with, or at least most of you probably are not familiar with. That's the Immigration and Nationality Act. So when you combine these two together, you've got crimmigration, which is basically what are the immigration consequences of New Jersey criminal activity. I do have a website. It is called njcrimmigration.com, NJCR for New Jersey Crimes, and then immigration.com. There are dozens and dozens and dozens of opinions as to what type of New Jersey convictions will result in deportation or removal. It runs the gamut from eluding to possession of cocaine. And I just want to stress, this is not an immigration course. There are hundreds of immigration courses. This is not an immigration course. It's really tailored for those folks that practice in those areas that I've just mentioned. We're going to be talking about your foreign national clients, your foreign national defendants. We've got a lot to cover, and if you do practice in those areas, I do think you're going to learn a lot today. All right. So, here are some of the immigration statuses. And the first one that's up here, U.S. citizen, you may scratch your head on that, but don't ignore that one. I can't tell you how many times where one of my clients doesn't even realize he's a U.S. citizen. His mother's a U.S. citizen, but he was born in Poland, and nobody ever bothered to get him a U.S. passport. He's a U.S. citizen. His mother's in the United States. Gave birth when she was in Poland, but came here, and the mom became a green card holder and then a U.S. citizen, and her son was under 18 years old when she became a U.S. citizen. Well, guess what? By operation of law, he's a U.S. citizen, and if you're a U.S. citizen, you don't have to deal with the immigration service, period. Lawful permanent resident, everybody knows what that is, a green card holder, even though, I don't know why they call it green card. The cards are pink. But it's a green card. Temporary visitors, those would be students, people that come here on B2, B1 visas. B2 is for tourism, and B1 is for business. EWI. EWI stands for Entry Without Inspection. That is basically one of your clients that has snuck across the border, either on his own accord or they've used a coyote. And I think the price is about $10,000 a person these days. DACA, Deferred Action Childhood Arrival. You may have heard about President Obama's executive actions, and we'll talk briefly about the expansion of DACA in a little bit. And then there's the Deferred Action Status. These two are actually no status at all. What it is really just discretion on the government's part to keep you here. And I do have some clients in deferred action status because they assisted the government, and the government was able to arrest 3 drug dealers. So they've decided to just put this person in deferred action status and keep them around, not deport them. And there are 60 other different kinds of visas, which, if you want to know about, you've got to take an immigration course. All right, so inadmissibility. What is inadmissibility? It's a legal fiction. Mere presence in the United States does not mean that the foreign national lawfully entered or was admitted to the United States. You had to have been inspected and authorized by an immigration officer in order to be admitted. And in that book that I just showed you, INA, the grounds of inadmissibility meaning the grounds where they're going to turn you away at the border or they're going to put you back on the plane to Jamaica, is found in INA Section 212 in this book. And again, we're talking about foreign national criminal defendants. So let's talk about deportability, and then we're going to get to the point as to why do you have to know this. Deportability. A foreign national has been lawfully admitted to the United States and then commits a crime. You'll find those grounds of deportability in this book again in the INA Section 237. This is where your foreign national criminal defendant, he came here legally. He had a green card, he had one of those visas we just spoke about. He was inspected either at the airport or at an embassy before he got his visa, and he was admitted into the country, as opposed to somebody who snuck across the border. So inadmissibility, deportability. And here is probably the most important question. Why does a criminal defense lawyer or a municipal court practitioner have to know that? Well, there are different immigration consequences between the criminal grounds of inadmissibility and deportability. An example, a New Jersey criminal conviction may not have the same effect on a green card holder as somebody who snuck across the border. Let's take an example. A theft offense. Let's pull one of them out. 2C:20-3. Theft offense, let's call it third degree. If there's a green card holder who's been convicted of that theft offense, but after 5 years of the green card being in his pocket, he gets a pass. He's not going to be deported. He's not going to be removed as a result of that theft offense. But that same foreign national who doesn't have a status, the EWI, the entry without inspection, the guy who snuck across the border, he's inadmissible. And once he either serves his time for probation or if he gets put in jail, he absolutely positively will be removed from the country. So it's important. What is your client? Is your client inadmissible or is he deportable? Now, let's take a look at this example. A New Jersey criminal conviction may only affect a green card holder if he leaves the country. All right, so that same green card holder who's had the green card in his pocket for more than 5 years decides to leave the country and he goes to Italy on vacation. Comes back with some terrific oil, olive oil and whatnot. If he's been convicted of that same theft offense, he can't get back into the country. He's inadmissible because he left the country. All right. And he's going to be put in deportation proceedings. Now, it's a whole nother course to talk about how do we keep him here, what relief is available. That's not the topic of this discussion, but he can't get back into the country. So let's see who's paying attention. Inadmissible or deportable. Mexican foreign national is here for 10 years, okay? He got here via that coyote that I spoke about, somebody that snuck him across the border. He gets pulled over for a DWI. He's got some coke in his left pocket or in the car. ICE shows up. He is, we got inadmissible on this room. We got deportable on the other room, on the other side of the room. Which one is it? It wouldn't be both, and it wouldn't be deportable. Was this guy inspected? If he was an EWI, if he snuck across the border, was there some Customs Border Patrol officer who took a look at his visa when he got off the plane, or if he came in on a boat or something like that? Was he inspected? No. He snuck across the border. He was an EWI. So he's inadmissible. He's inadmissible. All right, so the Polish foreign national gets here with a B2 visa. And it's going to expire in 6 months. He gets busted for only simple possession of pot. Only simple possession of pot. ICE shows up. He is? Absolutely. He's deportable. Why?
Because he was inspected.
Perfect. He was inspected. He had the B-2 visa. He went to the U.S. Embassy in Warsaw. He got the visa put in his Polish passport, and somebody looked at that and somebody inspected him. So he's deportable. All right. This one's a giveaway. It's got to be. The Italian foreign national with the great olive oil with a green card has a criminal conviction for theft. I talked about it, 2C:20-3, 27, whatever you want. He travels to another country for vacation. When he returns to JFK, he's... Exactly. And why is he inadmissible? He's got the criminal conviction, and he has to be re-inspected now. The game has changed. If he didn't have the criminal conviction, he wouldn't be inadmissible. But takes him out of the box, brings him back to square one. We've got to take a look at him again to see if we're going to allow him in the country. It's almost like two different classes. We've got to get through some of this stuff. So there are different criminal grounds for inadmissibility versus deportability. If you're one of those EWEs that's never been inspected before, this is the stuff that's going to bust you up. If you're a green card holder or you've been inspected, this is the stuff that's going to remove you from the country. So let's take a look. A conviction or admitted commission of any controlled substance offense. Let's compare that with somebody who's been inspected. Conviction of any controlled substance offense other than a single offense for simple possession of 30 grams or less of marijuana. So this guy gets kicked out of the country if he's got a joint in his pocket. This guy doesn't, as long as it's less than 30 grams. All right, conviction or admitted commission of a crime involving moral turpitude, and we're going to talk about that later on. And there is an exception which we will talk about. It's called the petty offense exception, and all of our DPs, the New Jersey disorderly persons offenses, fit into that category. A conviction of 2 or more offenses of any type with an aggregate sentence of imprisonment of at least 5 years, prostitution and commercialized vice. Not inspected, these are the grounds of inadmissibility. So let's go back to deportability. We spoke about any controlled substance other than a single offense of simple possession. A conviction of a crime involving moral turpitude committed within 5 years of admission to the United States and punishable by a year in prison. That was the example of the green card holder who got busted and pled guilty to a theft offense, 3rd degree. But he had the green card in his pocket for 5 years. So there's his pass, because it's committed within 5 years. So that's his pass. If it was committed 2 years after he had the green card, he gets put in deportation. All right, conviction of 2 crimes involving moral turpitude at any time, regardless. So if he got busted for 2 theft offenses, both 3rd degree, no pass, right? He's going to be deported. You're taking pictures, huh? You need a wide-angle lens to get this nose in there. All right, so interesting enough, conviction of a firearm or destructive device. So this guy who gets busted for having a gun, there's none on this side. You're not inadmissible if that same EWE gets busted with a gun. Now, it may be a crime involving moral turpitude, depending on the facts. Maybe he used the gun to rob somebody. Maybe it was in his trunk. But, see, they're different. The grounds of inadmissibility versus deportability are different. So we have to know who and what we're talking about. Conviction of a crime of domestic violence, stalking, child abuse, child neglect, child abandonment, a violation of a temporary restraining order, whether it's civil or criminal. In New Jersey, it's always, domestic violence is always civil, right? When you get a restraining order, it's always a civil action. And then a conviction of an aggravated felony as defined in this section, which we're going to go over in length. So you may say, well, wow, not too much on this side, but this entire category here, more likely than not, is a crime involving moral turpitude. Domestic violence, stalking, child abuse, child neglect, abandonment, and a violation of a restraining order would all be considered crimes involving moral turpitude. All right, so let's talk about some of the free passes that some of your foreign national defendants are going to get. And that would be the petty offense exception. Under the category of inadmissible, maximum sentence possible does not exceed 1 year, and you're not sentenced in excess of 6 months. So what does that sound like? All of our DPs, right? I mean, maximum sentence is 6 months, and quite frankly, I've never seen a judge impose that kind of a sentence in municipal court, though I guess it is possible for a DP. Regardless of the actual time spent in jail, even if the judge suspends the sentence, it equals the sentence. So there's no such thing. If the judge suspends it, it still counts as you being in jail and serving time. All right, so here's the petty offense exception for somebody who was inspected and is deportable. Maximum sentence possible is less than 1 year. All right, so again, that would be all of our disorderly persons offenses. This doesn't fall under the petty offense exception, but it's another get-out-of-jail card for someone who has a green card or someone who has been inspected. If it's a fourth-degree crime or even higher, but it's a crime involving moral turpitude, and again, committed after 5 years of the green card being in your pocket, you get one free bite at the apple, and you are not deportable. And this does not apply to aggravated felonies. You can have an aggravated felony endangering the welfare of a minor where somebody got probation. That's an aggravated felony. So this would not, if it happened a year after, if it happened 10 years after he had the green card and he pled to endangering the welfare of a minor, regardless of the sentence, he's absolutely positively deportable because it's an aggravated felony. All right, so let's talk a little bit about domestic violence. In order to be deportable, and I underline that word, and I'll explain why in a minute. In order to be deportable for a domestic violence, it must be a crime of violence. A little bit more serious than the run-of-the-mill simple assault that you have in municipal court, and then you have the domestic violence final restraining order. It's got to be an offense that has an element, the use, the attempted use, or threatened use of physical force against person or property. That's one, because these definitions are found at 18 U.S.C. Section 16A and B. Any other offense that is a felony and that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense, you always have to look to the mens rea. If there is an element where it's purposeful, it's probably a crime of violence. Negligence is not going to cut it. That's not going to work. It's not a crime of violence if there's a negligence mens rea. You need specific intent to harm versus thoughtless or careless action. So, first-degree murder, that would be a crime of violence, obviously. Negligence in clowning around, driving down the wrong side of a street at 4 o'clock in the morning where there are no other cars, and if you accidentally strike another vehicle, that wouldn't be a crime of violence. There has to be an awareness and conscious disregard of that risk. It's not, criminal negligence doesn't work because there's a failure to perceive the risk. And in New Jersey, the eluding statute has the potential to be a crime of violence. You jump in a car, police officer's got the lights, and you try to get away from that police officer. There's a high probability that that would be considered a crime of violence. Now, I circled this word because, for the most part, we're talking about somebody that has a green card, somebody that has been inspected. So what about the person who just married a U.S. citizen and is about to get a green card? The act of getting a green card is discretionary. So if somebody pled out to a looting and it's a chance that it's a crime of violence, more likely than not, they're never, ever going to get that green card. All right, so let's quickly talk about President Obama's executive actions that he laid out on November 20th, 2014. There's one new program, and there's an expansion of an existing program. The new program is DAPA, Deferred Action Parental Accountability. And this is big for a lot of foreign nationals. If you were here on or before January 1st, 2010, and you have a U.S. citizen child, you're going to get work authorization and pay taxes like we do. You're going to get a New Jersey driver's license, and you're going to get a guarantee of no deportation for 3 years. However, if you plead guilty to domestic violence, and it doesn't have to fit into this rubric because they're not deportable. They have no status at all. They're typically EWIs. But if you pled guilty, or your client pled guilty, to a domestic violence in municipal court, they're not eligible for DAPA. If your client pled guilty to a DWI in municipal court, and they're an EWI, and they were here on or before January 1st, 2010, and they have a U.S. Citizen child, they're not eligible for DAPA. They are considered significant misdemeanors. New Jersey doesn't classify them that way, but that doesn't matter. The federal system does. They're significant misdemeanors, and your client's not going to be able to get work authorization, not going to get a guarantee of non-deportation for 3 years, not going to be able to get that New Jersey driver's license. DACA is a program that's been around since 2012. If you came to the country when you were under 16 years old and you have a GED or you went to high school, same thing. You get work authorization, you get a driver's license and a guarantee that you're not going to be deported for 3 years. Same thing. If you're convicted of domestic violence, simple assault in some municipal court against that individual's girlfriend or wife, you're not going to be eligible for DACA, and you're not eligible for DACA. All right, let's talk about the definition of conviction, because the definition of conviction for the federal government is very different than a conviction that we're all used to. It's a formal judgment of guilt of the alien entered by a court, or if adjudication of guilt has been withheld, where a judge or a jury has found the, I always hate that word. I like foreign national. Alien is something from Star Trek. But found the alien guilty, or the alien has entered a plea of guilty, or nolo contendere, or has admitted sufficient facts to warrant a finding of guilt, and the judge has ordered some form of punishment, penalty, or restraint on the foreign national's liberty. So, what about conditional dismissal in municipal court? Well, the way that statute is written, you have to enter a guilty plea, which is kind of silly. You don't have to do it for conditional discharge, even though it's worded in the conditional discharge statute, Section 30. So you could do either one, but all the courts or most courts don't require a guilty plea. Not the same with conditional dismissal. You have to enter a guilty plea. So this is very bad for your foreign national clients who enter a guilty plea to simple assault, and especially in a domestic violence context, and you think, oh, it's going to be okay because in a year it's going to be dismissed. No, it's considered a conviction. So any type of a guilty plea, or I know this would be unusual, but how about a conditional discharge where your client is exculpating his girlfriend and saying, yeah, the drugs was mine, really wasn't hers? That's a conviction. sufficient facts to warrant a conviction. And of course, we know the judge imposes some form of punishment. If you have to pay $1, that's some form of punishment. If the judge imposes any period of probation, that's some form of punishment. All right, so what does that mean for New Jersey convictions? Only a finality of conviction counts. So all times for all direct appeals have to have been expired. So if you have pled guilty in municipal court, you got to wait the 20 days. I mean, if somebody does file an appeal, same thing in Superior Court. Some of you know better than me. I'm not sure. Is it 45 days for you to appeal after you've been convicted or pled guilty in Superior Court? I think it's 45 days. All right. So a PCR is collateral. The filing does not change the finality of the conviction. It has nothing to do with this paragraph. All direct appeals have to have been expired. PCR doesn't do anything. All right, so any PTI, any conditional dismissal, or any conditional discharge with a plea is a conviction. But if you're able to avoid a guilty plea, that's not a conviction for immigration purposes. Now, to go back to municipal court, you're right. Nobody's ever required, that I can remember, a guilty plea for conditional discharge. But that new program for disorderly persons offenses, conditional dismissal, what's the first thing that has to be done? Your client's got to get fingerprinted. They have to enter a plea of guilty. That's a conviction, even though a year from now, after they pay whatever the amount is, it goes away. For immigration purposes, that's a conviction, and your client will either be inadmissible or deportable. All right, here's a very important one for those practicing. Juvenile delinquency adjudication is not a conviction. So you never, ever want to waive up to adult court if your client is a foreign national. Even if he pleads as a juvenile delinquent and he's got to do some time, and I don't know what it's called, Jamesburg, that is so much better than him actually waiving up to Superior Court and getting probation, because that's a conviction. Once he pleads to that charge that's now in Superior Court, same thing, he's either inadmissible or he's deportable. They are not convictions, and the immigration courts can't use them. They won't use them. They're not considered, and they can't, quite frankly, get the records. I mean, we can't even get the records. Important issue, important subject. Any other questions? Clear about what a conviction is. All right. I'm either confusing everybody or I'm doing a halfway decent job. Or you just don't care, which is okay. I'd be in the back room. I'd be listening to jokes from Tony. All right. So crimes involving moral turpitude. If you're confused, that's a good thing, because most of the courts really have no idea what a crime involving moral turpitude is. It's just so ambiguous. It has to be some type of crime that is base, that is vile. Forget the severity of the crime. A disorderly person's offense for stealing a piece of gum, that's a crime involving moral turpitude. Now, you may have the petty offense exception, to keep your client here, but that is a crime involving moral turpitude. You really have to look to the elements in the New Jersey statute to figure out whether or not it's a crime involving moral turpitude. The phrase moral turpitude is one of the most ambiguous in a long list of ambiguous legal phrases, and the cases are far from consistent. In fact, they're very inconsistent. Moral turpitude refers to conduct that is inherently base, vile, depraved, contrary to the accepted rules of morality. Prostitution fits in there, stealing, and the duties owed to other persons, either individually or to society in general. In determining whether an offense involves moral turpitude, It is a common mistake to consider whether the crime is a DP or a degree crime. Intentional theft of a piece of gum is a crime involving moral turpitude. The facts of your client's case does not determine whether an offense involves moral turpitude. If they did, immigration judges would be charged with retrying the criminal case in immigration court. Hence, they're supposed to look at the elements in the statute. They're not supposed to retry your client. The focus is on whether the elements necessary to obtain a conviction under that particular New Jersey criminal statute render the offense a crime involving moral turpitude. And here's really the most important aspect of this slide, what you really need to take away. Generally need a specific intent to do harm or knowledge of the act's illegality. Recklessness might be enough. Negligence is not moral turpitude. Hence, simple assault can be criminal negligence. It's not a crime involving moral turpitude. Any questions on, because that's a very difficult concept. Okay. All right. So let's talk about some New Jersey, specific New Jersey offenses and whether they are CIMTs. All right. So you can structure a theft offense and render it not a crime involving moral turpitude if you can somehow eliminate the permanent taking. So kind of hard to do with shoplifting, but the run-of-the-mill generic theft offense, you may be able to get an allocution from your client that, yeah, I took it, but I was going to give it back to him. That would render it a non-CIMT. That's why, joyriding, taking somebody's car with the intent of returning it an hour or a month later, is not a crime involving moral turpitude. Shoplifting is. Burglary, it's a CIMT if you're there to steal, not watch TV or sleep. So if I break into your house and I don't have the mens rea to steal something, I really just wanted to watch the latest reruns of The Sopranos, it's not a crime involving moral turpitude. And if you're really smart, like some of the criminal defense attorneys in this room, you may even change the burglary offense to trespassing. And if you want to learn how to do that, speak to the gentleman in the back. Bad checks, there is a intent to defraud is an element, so that's a CIMT. False documents, intent to defraud is not an element. This particular statute, and I'm going to just pull it up quickly because we really hit a home run on that one. We had a Polish foreign national. He had no prior criminal history. He was getting married to a U.S. citizen. She was pregnant. He had never been in trouble before, but he was involved with manufacturing driver's licenses and selling those driver's licenses. And what we were able to do is put him under that particular category, permit another to use the same for purpose of forging written instruments, including access devices, and personal identification. So the allocution was basically that he did have a fake license, but he didn't use it to defraud anybody. So he avoided the CIMT, he just got his green card, and I can tell you this guy is never, ever going to get in trouble again. I wouldn't bet my 2 mortgages on it, but I'm pretty sure he is not going to get into trouble again. All right, crimes of violence, we went into some detail about that. They are typically CIMTs, but bodily harm is intentional. It's knowingly caused or threatened. Almost all of the sex offenses are crimes involving moral turpitude. Now, this is interesting. A DWI in and of itself is not a crime involving moral turpitude, but all you have to do is append a driving while suspended to it, where the defendant knew his license was suspended. There's that knowledge element. That's a CIMT. And especially if he's got a DWI and a driving while suspended, and the suspension is due to a prior DWI, that is absolutely going to be viewed as a CIMT. You definitely want to try to get rid of those aggravating factors. All right, so CDS, controlled dangerous substances, they're not CIMTs. You know, you would think if somebody had some heroin in their pocket, that would be a CIMT. It's not. However, if you sell it to me, it is. Drug dealing is always a CIMT. And firearms, standing alone is not a CIMT, but it is a separate ground of deportability. Remember that section on this side where I said, wow, this guy could have a gun in his pocket, and it's a separate ground of removal where somebody who is inadmissible, there is no category. So it is a separate ground of deportability if you have a firearm and it's not registered to you and you're not supposed to have it. We spoke about the petty offense exception. It's the one free bite at the apple, maximum penalty 1 year in jail, and our DPs fall within this classification. All right. This is a very, very important topic. Criminal defense attorneys are now responsible for advising their clients of the immigration consequences when they're clear. The immigration consequences are not always clear, but they're absolutely clear when they're on this hit list. So you will, or that particular attorney will find himself in a situation, a PCR for ineffective assistance of counsel, if that attorney doesn't say, you know what, and we're going to go through the list, but you just pled guilty to sexual abuse of a minor, endangering the welfare of a minor in a sexual abuse context. That's an aggravated felony. You're absolutely going to be deported because it's crystal clear. The law changes a bit when the consequences are not as clear. In that case, the criminal defense attorney going forward now has a duty to say, you run the risk of being deported, but maybe you want to seek some advice from an immigration attorney or a crimmigration attorney. So anyway, these definitions are found, again, in the Immigration and Nationality Act book under Section 101A43, and there's no relief available to a foreign national who has pled guilty to an aggravated felony. And there are three categories of aggravated felonies. The first one would be offenses that are aggravated felonies just by their very nature. The next one would be offenses that are aggravated felonies based on the monetary amounts involved. So what comes to mind? Theft. It's got to be some type of fraud, maybe. Some type of monetary amount or loss to a victim. And then offenses that are aggravated felonies based upon a sentence. Burglary, got sentenced to more than a year jail. So, all right, let's take a look at them individually. The nature of the offense. Some pretty obvious ones. Murder, rape, sexual abuse of a minor. And I keep repeating endangering the welfare of a minor because that is sexual abuse of a minor. That New Jersey statute is sexual abuse of a minor, regardless of the facts in the case. There was a situation where had a 16-year-old brother and a 12-year-old stepdaughter, or they were sister and brother, but stepdaughter or a family sibling relationship. And we appealed the case to the Third Circuit, and they sort of throw the rule book out when it comes to this stuff, regardless of the mitigating circumstances. It was a dysfunctional house. It was his sister that always knocked on his door. Didn't matter. And there was a dismissed count in the indictment, but the Third Circuit relied even on that dismissed count. So the rule book gets thrown out. I hate to say this, but don't ever expect to win these cases if your client has pled guilty to sexual abuse of a minor. And I'm not here to judge, but, perhaps the father who's sleeping with his 14-year-old daughter, well, maybe he should be deported. But this particular case that went to the Third Circuit, boy, there were some unbelievable extenuating circumstances, and he got deported back to Colombia, and, I'm not sure he's probably involved with all kinds of stuff. Anyway, drug trafficking is an aggravated felony. Firearms trafficking, including bombs, destructive devices. Any type of prostitution business, aggravated felony. Human trafficking, aggravated felony. Kidnapping, any type of child pornography. So those are obvious. And if your client's pleading to one of those, and you're a criminal defense attorney, you now have the obligation to tell him you will be deported. Otherwise, expect some type of ineffective assistance of counsel claim. All right, so the next category are the monetary amounts. Money laundering involving funds in excess of $10,000, fraud or deceit where the loss to the victim exceeds $10,000, tax evasion where the loss to the government exceeds $10,000. Do you think it might be ineffective assistance of counsel if your client is charged with $10,000 and you don't try to get the allocution reduced to $9,999? Maybe. Maybe. Same thing with fraud or deceit. Okay, so sentence imposed exceeds a year. It's the same question. Do you think it might be ineffective assistance of counsel if it's 365 days and the prosecutor would have given you 364? Might be. Might be. So any one of these offenses where the sentence imposed exceeds 1 year: theft, burglary, crime of violence, possession of stolen property, don't see too much of that, bribery, counterfeiting, obstruction of justice. All right, so let's talk about some New Jersey aggravated felony crimes that must be avoided. This keeps popping up because I lived with it for many years. So be very careful with the statute. If you can, get an allocution to the non-sexual part. That's great. Aggravated assault with a imposition of jail. And again, suspended sentence doesn't count. If the imposition of jail is a year and the judge suspends the sentence, it doesn't matter. What is the sentence? The sentence is equal to or greater than a year. Same thing with theft, burglary, possession with intent to distribute a CDS. And then we're going to talk about some safe havens. And what I mean by safe havens is just simply safe pleas. Pleas that your client can enter to avoid the aggravated felony definition. All right, so here's some New Jersey safe havens, and there's the first one. Endangering the welfare of a child. You want to eliminate the sexual conduct. All right, so possession with intent to distribute any controlled substance except a small amount of marijuana for no remuneration, for no money. Let's spend some time on this one, all right? Your client is charged with distribution of marijuana. If you can somehow convince the prosecutor, and perhaps after you speak to your client in exchange, if he was going to give you probation because it's a relatively small amount of marijuana, I don't know, let's say it's 2 or 3 ounces. If he was going to give your client probation, you may want to speak to your foreign national criminal defendant client about maybe in exchange for some jail time, I can convince the prosecutor to go along with this. Maybe the allocution can be, well, you know what? I was sharing it with some of my friends. It was a small amount and no money was exchanged. You've just taken it out of the aggravated felony category and you're a hero. You really, really saved your client. I don't like to talk about too many war stories, but this one, especially for the criminal defendants in the room, criminal defense attorneys in the room. There's a derivation of this, 35-7, which is distribution in a school zone. If you can get from the prosecutor permission to allocute from your client, basically, it's always got to be pot. Any other offense, forget, or any other drug just doesn't work. But if you can get permission from the state to allocate as follows, again, it's a home run. Your client had a small amount of marijuana that he or she was sharing it. You're going to have to indicate that it was under 5 grams and that it was shared for no money next to a school bus. Why? Well, the federal grounds of removal says school and school only. What does 37-7 say? School bus. So we recently did that in a case, and woman from Guatemala, she's been here since she's 3. She speaks better English than I do. Mother went through 3 fathers or stepfathers. She was sexually abused, so she was stealing out of her house, and she was definitely going to be gone, but we managed to have it couched in those terms, and we went through the immigration process, and she dodged a bullet. And I told her if she gets in trouble ever again, she is and I used a bunch of expletives, because she really did dodge a bullet here. There were a lot of mitigating factors in her life. But if you could get that type of allocution, quite frankly, that's a grand slam. That's the reason why not less than 30 grams, less than 5 grams. School zone. Regular run-of-the-mill distribution, you can do a small amount. In fact, I would keep the amount out of the allocution unless the prosecutor is willing to say, yeah, you could say it was a couple joints. All right, criminal sexual contact in which the age of the victim is not an element. This is another way to eliminate sexual abuse of a minor if you can move from those statutes that have a specific age to one that doesn't. And these statutes don't. They're aggravated criminal contact in which the victim is helpless, but there's no minor. There's no sexual abuse of a minor. It's not an aggravated felony, but it still is a CIMT. All right, so reduce the jail sentence to 364 days and reduce the monetary loss to less than $10,000. All right, so let's talk about specific issues in New Jersey Municipal Court. All right, so you may or may not have seen this disorderly person's offense: possession, use, or being under the influence, failure to make lawful disposition, failure to turn over, or under the influence. It's a DP, no problem, right? Shouldn't be a problem. Wrong. Unless it's marijuana and it's under 30 grams. But what about the situation where your client, the foreign national, is at some party and cops come in and raid the party, and they find that your client has a bunch of coke under his left nostril. He doesn't have anything on him, but it's clear he's got it under his left nostril, and they charge him with this. It's only a disorderly person's offense, right? So that shouldn't be a problem. You might as well plead him guilty to that. Absolutely not. Because it's cocaine, mandatory detention. And, you know, I'm not that creative. I had that case. Another guy that was here from Mexico, been here since he was 2. And he was at some party, little cocaine under his left nostril, paid somebody a couple thousand, they pled him guilty. mandatory detention. He's never been in jail before. He's 22 years old. His girlfriend came to the office crying. I had to run in on a PCR and get that changed to just the state couldn't believe what was going on. The judge couldn't believe what was going on. He had no priors. We changed it to disorderly conduct, 2C:33-2A or B. I can't remember. We got him out the next day. In fact, he married a U.S. citizen, and she's having a child. So that was his mistake, but don't make that be your mistake. Marijuana, okay. DP with anything other than marijuana, big, big problem. All right, so conditional discharge, we went over this. Do not allow your client to plead guilty, and most of the times they don't. But if they're trying to exculpate their girlfriend and say, yeah, the drugs were mine, not hers, you got a problem, even with conditional discharge. Don't allow your client to make a statement of possession on the record. A reopener may be too late. What do I mean by that? If, in fact, you go back in and try to reopen that conditional discharge, and I've done that before, it may be too late for immigration purposes. Drug paraphernalia, all right? The immigration courts consider this to be a controlled substance violation. And if there's any indication that the drug paraphernalia related to something other than marijuana, you got a big problem. If it's pretty obvious on the face of the complaint that he's pleading guilty to a hypodermic needle or a crack cocaine pipe, you got a big problem. Loitering, I mean, you would think that's a throwaway. It's not even in our sections for controlled dangerous substances, the 36s, the 35s, but it's not a good deal for the foreign national. They lose out on a potential waiver, the 30 grams of lesser marijuana. What if the allocution is, yeah, I was loitering in the city of Passaic to get heroin? You got a problem, a big problem. If you have to plead to something like that, make sure that the allocution is something along the lines that I was loitering for the purposes of obtaining a joint. All right, shoplifting is a CIMT, but here's a very popular safe haven, which would be disorderly conduct. It really is just so neutral. There really is no mens rea. So it's a neutral factual basis. I was in Wayne and created a disturbance. You've protected your foreign national from having a crime involving moral turpitude. No effect whatsoever. Expungements are completely irrelevant in immigration court. Now, they may be something you want to do for your client because he's going on a job interview. That's different. But it absolutely, positively has no relevance in immigration court, and they will get the records. They can go behind. A green card holder or an iwi doesn't have the same rights that we do. They can't vote, and that expungement, the ICE or the trial attorneys, they can get those records. An expungement has absolutely no effect. It doesn't help your client in immigration court. In fact, in some cases, it's a problem because you've sealed the record and they know he was arrested, and now the immigration judge wants to see. They're sealed. Now you got to go back in and ask the judge to unseal them. So they should never, ever be done for immigration purposes. If there's another legitimate reason, like an interview or something like that, all the merrier. All right, so now we're going to get into controlled substances violations. So not all drugs are controlled substances. It's illegal to possess cancer drugs from Haiti. That's a crime, but it's not a controlled dangerous substance. So for some of the criminal defense practitioners should be thinking, well, maybe I have to find, and the prosecutor may or may not allow you, but maybe I have to find a drug that's not on the federal schedule. And I think there are a lot of these steroids, and some of them you can buy, I think, at even the health stores, that you may be able to fit the defendant or the allocution in this type of a situation. So it wouldn't be a removable offense if it's not on the federal schedule, okay? It's not a controlled substance if it's not there. All right, so controlled substance violations are independent grounds of inadmissibility and removability, and we spoke about that on the first or two slides. If you're an EWI, even if you have marijuana, but if you're a green card holder, you get the free pass, the under 30 grams. You do not need a conviction or even an arrest on his record. Reason to believe he is a drug dealer is sufficient to be denied admission to the United States. So what do I mean by that? All right, so somebody's coming from, I don't know, I'll pick on the DR, and they get put into what's known as secondary processing, where a Customs Border Patrol agent may ask them a series of questions, and if some of the questions indicate that maybe he's used drugs or maybe in the past he's sold a joint, he is going to be denied admission to the United States. You don't need a conviction. You don't need a conviction. Green card holder returning from abroad, convicted or admits, same thing, going to be denied admission back into the United States. And, you know, the admission could be right with the CBP officer. They could ask some questions about, so I see you were arrested, and you know, what happened? Well, you know, I had some cocaine, but my criminal defense attorney was so good, he got it dismissed. It's a problem, big problem. Simple possession of either crack or roofies. I always struggle. Flunitrazepam. Those are aggravated felonies. Simple possession of crack or roofies, that's aggravated, so you never ever want to plead somebody to crack or roofies. And I think in New Jersey, we don't specify anyway. I think it's just a general cocaine in the statute. I don't think it spells out crack. I'm not sure. Some of you guys know better than I do. But you certainly would not want to allocute to either one of those, because you've just given your foreign national criminal defendant a life sentence back in his home country. You know what? I'm going to take a couple of minutes to just read some of the blurbs from, you know, Padilla and some of the other cases. So, with Padilla, requires defense attorneys to advise as to the risks of deportation to the foreign national. When the immigration consequences are easily obtained, the criminal defense attorney must advise the client. When the immigration consequences are complex, the duty to advise is more limited. So complex equals there's a duty to advise. Charges may carry a risk of adverse immigration consequences. If it's clear and not complex, you absolutely positively have that obligation. Otherwise, you're going to find yourself the subject of a PCR. And what is the definition of clear? Well, that probably is going to change over time, but for right now, it's those aggravated felonies. I mean, they jump off the page. Murder, sexual abuse, drug trafficking. So, that's the obligation. Justice Alito, in his concurrence, he was joined by Chief Justice Roberts. He summarized the duties of defense counsel. One, this one seems pretty obvious. They must not give unreasonably incorrect advice. Okay? They must alert the client that a plea may have deportation consequences. And three, they must tell clients that if they wish to know more, they should consult with a immigration or crimmigration attorney. The majority expects you to affirmatively explain what the deportation consequences of a plea will be. Ineffective assistance claims may be substantiated on grounds other than giving affirmative misinformation. It's mandatory to advise on the subject as part of providing constitutionally effective assistance of counsel to a pleading non-citizen criminal defendant. So prior to Padilla, if you said nothing, if you said zip, you were okay. If that person was pleading guilty to sexual abuse of a minor and you didn't say, hey, you're going to be deported, you were okay. Now you must tell them. Now, this hasn't changed. If you've given wrong advice, that's always ineffective assistance of counsel. Well, depends on the advice, but it doesn't have to always be immigration-based. But after Padilla, you must give advice. You must now tell the client you are subject to mandatory deportation in aggravated felonies. That's in the case. Gaetan basically says there's numerous resources are available to criminal defense attorneys, so there's no reason for you not to know. Not so sure about that. Some of the resources that I look at are from 2005. You see it up on the internet. Gaetan, even if not on the hit list of aggravated felonies, criminal defense attorney must highlight for non-citizens that pleading guilty will place them at risk of being deported, and they may seek crimmigration advice from counsel. And the courts are going to look to the transcript of that allocution to see whether or not this occurred, whether or not this particular conduct occurred. All right. So, back to mandatory detention. Non-citizens who have committed certain offenses must be detained, i.e., disorderly persons offense, small amount of cocaine under his left nostril. Go figure. Without bail by ICE, that's the Immigration and Customs Enforcement, during the pendency of their removal proceedings. There is a little section here. This is a very interesting Third Circuit Court of Appeals case. We conclude that 8 CFR Section 287.7 does not compel state or local law enforcement agencies to detain suspected aliens subject to removal proceedings pending release from immigration officials. Section 287.7 merely authorizes the issuance of detainers as requests to local LEAs. Given this, Lehigh County was free to disregard the ICE detainer, Galarza versus Salzik. In that case, ICE officials asked the sheriff or asked the warden if they would put a detainer on this particular foreign national, and they didn't want to. And so the case went up to the Third Circuit. It's only a request. So if you have any type of relationship with the warden or the sheriff, give them this case, they can cut the guy loose. And we have had situations, and listen, the facts have to be right. They're local enforcement agencies. They are, in fact, police officers. If they've got a jacket, that's a mile long, it's not going to happen. But, the person that has one prior shoplifting offense and maybe is facing, a possession of marijuana, they may be willing to say, you know what, we're not going to detain that person, and we're going to let him go back home for Christmas and for New Year's. Just very quickly, I want to go back to President Obama's executive actions. And he did something else besides DACA and or the expansion of DACA, the creation of DAPA. He actually changed or eliminated, it's called secure communities. Secure communities is basically where your foreign national defendant maybe gets pulled over for DWI or speeding, and the local police officer sees he's got a license from Michigan, it's suspect, and he decides to give ICE a call. Well, that person would now, or prior to November 20th, 2014, would be put in removal proceedings, and there may or may not be an immigration bond available to them. Well, President Obama eliminated secure communities. It's gone. It was replaced with something called priority enforcement. And what they basically did, and it makes a lot of sense, at the top of the scale are serious crimes. Those are the folks that have to be detained, and those are the folks that have to be deported. That iwi that doesn't have any prior criminal convictions, they're off the priority list. They're not supposed to be detained. They're not supposed to be put in removal proceedings. And I'm starting to see it already. Had a Jamaican foreign national, I don't know, she was in Hackensack, I think, I forget which town, but gave a fake name. She got brought down to the county jail, and normally she would be held because she's here undocumented, she has no status, she only had a visitor's visa, long expired, 10 years ago. They released her. There was no detainer. So generally speaking, there's not supposed to be detainers for that category of people. So at the top, first priority are criminals, and the last category are those foreign nationals with deportation orders after January 1st, 2014. So even if they have a prior deportation order prior to that, they're not on the list. And that method of enforcement is not supposed to happen anymore. So if you know anybody that is detained, you could probably get them out, depending on the circumstances. If they fit that category and they're no longer on that priority list, they just haven't been released. What are the crimes that result in mandatory detention? Surprise, surprise. Aggravated felonies, any controlled dangerous substance offense other than simple possession of less than 30 grams of marijuana, 2 crimes involving moral turpitude for green card holders, 1 crime involving moral turpitude if sentenced for more than 1 year, and any type of firearms offense. So what that basically means is, even if there's a $15,000 county bond and your client is able to post it, they probably shouldn't have, because if they've pled guilty to one of these in the past, they're not getting out of jail anyway. They'll get moved. They'll get moved from Bergen County to Essex County, but they're not getting out. So if they paid a bail bondsman 10%, 20%, that money's gone. Since we're on the subject, when do I tell my client's family to post the county bond or county bail? Well, when your client doesn't fit into that category of mandatory detention, those crimes that we just went over, and when there's a high probability that your client will get a bond from ICE or the immigration judge. Now, and it's no different than Superior Court. The judge has discretion, and more likely than not, they are going to allow a bond. It starts at about $5,000, works its way up. But if your client has been charged with endangering the welfare of a minor, chances are the judge is going to determine that your client is a danger to society. No bond. You're going to have to wait for the immigration proceeding to wind itself through. They're not getting out of jail. But hopefully those cases are far and few in between. So let's talk a little bit about post-conviction relief. So the first ground of legal invalidity. To eliminate a conviction, a PCR must be granted at least in part because of a ground of legal invalidity. Something was unconstitutional, violation of the Sixth Amendment, something that was in existence at the time the conviction first occurred. Ground of legal invalidity number 2, relief granted solely to avoid immigration consequences or because of rehabilitation or favorable equities that happened after the plea will not erase the immigration consequences. So what are we basically saying? You have a nice guy, prosecutor's convinced, wow, 5 kids, he's really a nice guy, let's grant this PCR because I want to give this guy an opportunity to continue to work and pay for his children and pay for his children's education. It's not going to work. If he's in removal proceedings and if that's the basis for that PCR, he's a drug addict, we want to get him some help, he's a good guy, once he gets sober, it's not going to work. You will have gone through the exercise of a PCR, spent whatever months, evidentiary hearings, if the order doesn't mention some type of ground of legal invalidity, some violation of the United States Constitution, the New Jersey Constitution, you just wasted your time. It will have no effect whatsoever. Here we are, matter of Pickering. This is the Board of Immigration Appeals. It applies only to vacating convictions. The vacatur can be based in part on immigration consequences. He's a good guy. We want to rehab him. We want him to take care of his family. But so long as it's also based, at least in part, on a ground of legal invalidity, some type of constitutional infirmity. All right, so sentences. Sentences may be effectively changed for any reason at all, even immigration consequences. So, your guy pled to burglary. The sentence was, 365 days. You can go back in, explain to the judge, would you please modify the sentence to 364? And that would work for immigration purposes. Sentences. Okay? So this Pickering case, which basically lays this rule out, is only for convictions, this is a sentence. All right, so Padilla claims, and we've gone through this, holding counsel must affirmatively give accurate immigration advice before plea to render effective assistance of counsel. This requires 1, deficient performance by counsel, 2, prejudice, a reasonable chance of a different outcome absent error, and there's the cite. All right, so let's talk about ineffective assistance of counsel claims after Chaidez. We know, we went over it, Padilla requires defense counsel to give accurate immigration advice before the plea. And Chaidez reaffirmed Padilla's holdings that professional norms since '95 required defense counsel to advise of immigration consequences. It even cited a 1968 ABA standard that did so. And we really discussed this, but the bottom line is, if the immigration consequences are clear, you better tell your criminal defense client what the immigration consequences are. If it's not so clear, the standard is waxed or loosened, and you can tell them there's a risk that they might be deported and that they should probably go speak to somebody else. Same thing with Gaitan. And of course, the court is going to look at the transcript if somebody files that PCR alleging ineffective assistance of counsel. Some specific ineffective assistance counsel claims, a failure to advise on the immigration consequences. We know it's not retroactive. Prior to Padilla, you could say nothing and you're okay. Affirmative misadvice, this is still the law. Nunez, Valdez, affirmative misadvice concerning immigration consequences can be retroactive, and Chaidez does not apply to this ground. Affirmative misadvice, too, can be about any topic, not just immigration. It could be anything that, criminal defense attorneys are involved with, not just the immigration consequences. Okay, wow, that's filled with a lot here. Let's just take a look at some potential future ineffective assistance of counsel claims and what I've just labeled as, in my opinion, because the law seems to be changing, problems to look out for. All right, a failure to defend against adverse immigration consequences. Even if correct immigration advice is given, defense counsel has a duty to try to prevent bad consequences. I sort of call this the axe coming down on your client's head. All right, we know the axe is coming down. He's going to be deported, but what are you doing to try to stop the axe from coming down? And there is some case law that recognizes this ground. Padilla is inapplicable since it only deals with advice. Many cases predating Padilla recognize this ground. So is that in our future? Is that down the road, somewhere on the chessboard? So failure to defend. All right, failure to investigate immigration status to use as a tool in defense of the criminal case, such as trying to reduce the sentence. from 365 to 364. Let's see, this duty has existed since Strickland in '84. This ground can neutralize a government claim that defense counsel had. This would be the prosecutor on your PCR saying, "Oh, it shouldn't. There should be no evidentiary hearing because defense counsel had no immigration-related duties because he or she was unaware of the defendant non-citizen status." I think you have an obligation to find out whether or not your client is a U.S. citizen. It doesn't take that much. Ask them for a New Jersey driver's license. Ask them for a passport. Ask them if they were born in this country. Ask them if their mother was a U.S. citizen. All right. Failure to mitigate plea or sentence. Again, since Strickland in '84, defense counsel has always had a duty to minimize a sentence. A sentence even one day greater caused by ineffective assistance of counsel is prejudice, and that's Glover versus U.S. Supreme Court. Padilla is irrelevant there. And then failure to negotiate effectively is a variation of the failure to defend ground. There's a case, Missouri versus Fry, U.S. Supreme Court, and Lafler versus Cooper, U.S. Supreme Court. And these cases establish that prejudice includes failure to negotiate a better plea bargain, not merely to take a case to trial with a better result. So that's very similar to the failure to defend. In this case, I saw a situation where a foreign national was eligible for PTI, but the criminal defense attorney never bothered to apply for it. It wasn't a second-degree offense. It was just straight-up cocaine possession. Just never applied for it. So, again, I raised the specter about how this law seems to be somewhat in a state of flux, seems to be placing more, perhaps unfairly, more and more questions or more and more duties on criminal defense attorneys. PTI with a plea is not going to protect a client. PTI without a plea, safe. No problem. So, for instance, do criminal defense attorneys now have a burden or another additional burden placed on them to advise the foreign national criminal defendants that are eligible for DAPA and DACA? Don't plead to that DV in municipal court because you won't be eligible. You won't be able to get a New Jersey driver's license. You won't be able to get work authorization. You won't be able to get protection for 3 years that you won't be deported. Do we now have an obligation to tell them that? I think the answer is no, because that is some form of relief. But I'm not sure, because it will prevent this foreign national from being deported if you advise them, don't plead guilty to that simple assault in a DV context in municipal court, and don't plead guilty to the DWI. We all know how difficult it is to win DWIs. Yeah.
Doesn't the judge have a duty to inform them that they will be deported?
The judge doesn't have a duty to, investigate. The judge has a script that they read, and it's pretty generalized. The judge in municipal court just has to say, if you are a foreign national, some of these things or some of these crimes or cases that you plead guilty to may result in deportation. That's the extent of their obligation. In Superior Court, now they changed the form. Question 17 now says, if this is an aggravated felony, you will be deported, not may be deported. It's easy to say you may be deported, and Padilla changed that. You now have an obligation to tell them you absolutely, positively will be deported if it's clear. And, if you've pled guilty to murder or sexual abuse of a minor or some of those other items on the hit list for aggravated felonies, you now have that obligation, where before you didn't have to say anything. So I don't know whether or not that additional burden will be heaped upon criminal defense attorneys, and time will tell. I just want to go over what the process in immigration court is so that you just have a better idea. Service of an NTA, notice to appear. This is the analog to a charge in criminal court, but it's in civil. And there will be a bunch of allegations. You are a foreign national of Mexico. You entered illegally across the border. We don't know when. You're not authorized to stay here. So there may be 3 or 4 paragraphs where a immigration attorney, and I'm seeing quite a few criminal defense attorneys doing immigration work now, which is good. They will either admit or deny the allegations in the NTA, okay, as to being factual or not. And then there'll be another section at the bottom that says, and here is the ground of admissibility or removability. In the case of an iwi, you're not authorized to be here, and they'll cite the section under 212. In the case of a green card holder, you're deportable, and they'll cite the section of the grounds for deportability. And they have what's known as a master calendar hearing. It's sort of a cattle call where there is all kinds of folks. I've got to speed this up. Then there's a bond hearing right after the master calendar. The bond is either granted or denied. And then there's an application for relief, which this course is not about. There's a million different forms of relief. And then you have a mini trial. That's what the merits hearing is. Judge, I'm entitled to this relief. Here's why. Immigration judge makes the decision. It can be appealed to the Board of Immigration's appeal. The BIA, Board of Immigration Appeal. This is not the final decision. You can actually go to the Third Circuit, which is one step below the the United States Supreme Court. All right. Anybody? If you do any type of federal criminal defense work, the Armed Career Conviction Act, what was it? Armed Career Criminal Act of 1984. They used something called the categorical approach. When you had a federal criminal defendant that was facing a charge but has prior crimes from the various 50 states, and they're either violent felonies or serious drug crimes, you went through the categorical approach. You didn't retry the case. And that's where this came about, and it's now being used in immigration court. The facts aren't important. It's whether or not this crime, the New Jersey crime, is a categorical match with the federal grounds of deportation. So where the New Jersey criminal statute defines the offense broadly, the immigration grounds of removal issue, the conviction will not trigger, not going to be deported here, because this statute is more broadly endangering the welfare of a minor. More broad, we've got 2 things: sexual abuse of a minor, but then we have just regular abuse of a minor and sexual abuse of a minor. All right, this would be a categorical match. They would be deported. All the elements of the New Jersey statute match the elements of the grounds. Possession of cocaine, that person is going to be deported. And this is a chart. It's in my book, which is just another failed marketing attempt. But it's got a chart that sort of, it goes through the decision tree of what occurs in the categorical or modified categorical approach. Yeah. My function when a criminal defense attorney calls me is, number 1, try to figure out whether the charge is going to result in some type of grounds of removal or deportation or inadmissibility. Number 2, try to find a solution how to keep the person there. Plead them to this, not that, and then, sure, recommend any other type of relief. Any other questions? I can stick around. It looks like we're quickly getting the boot. Thanks so much. Appreciate your attendance.